Charles Landura, a member of the Technical Committee.
Good morning, honorable members. I'm Reverend Axon Banda, member Technical Committee.
Good morning, Chairperson, and good morning, honorable members. My name is Bishop Omsusu, a member of the Technical Committee.
Good morning, Chair, and good morning, honorable members. My name is Reverend Rodwo Chinyakasa. I'm a member of the Technical Committee.
It can't come.
Okay.
Good morning, Chair. Good morning, honorable members. My name is Wamundela Waluya, member of the committee. Thank you.
Good morning, honorable members. My name is Gregory Chifire, member of the Technical Committee.
Morning, honorable members. Thank you, Chair. Good morning, honorable members. My name is Robinson Chongo, a member of the Technical Committee.
Good morning, Chairperson. Good morning, honorable members of Parliament. My name is Ruth K. Kangwa, the youngest member of the Technical Committee.
Good morning, Chair, and good morning, honorable members of Parliament. My name is Douglas Tambulukani, a member of the Technical Committee. Thank you.
Good morning, Chair. Good morning, members of Parliament. My name is Ngande Mwanajit, a member of the committee. Thank you.
Good morning, Chair. Good morning, honorable members of Parliament. My name is Grace Manyonga Sinkamba. I'm a member of the Technical Committee.
Honorable members, starting with those on my right.
Thank you, Chair. Good morning, Deputy Chairperson and your team. I'm Jacqueline Sabao, Member of Parliament for Jigakata constituency. I'm the Vice Chairperson of this Select Committee. I welcome you.
Thank you, Chair. Good morning, witness. My name is Simon Banda, representing the wonderful people of Petauke Central. I'm also a member of this Select Committee. Thank you.
Kakubo Stanley, I represent Kapirimposhi constituency.
Thank you, Chair. Good morning, members of the Technical Committee. I'm Emmanuel Banda. I'm Member of Parliament for Muchinga constituency in Serenje District. Thank you.
Thank you, Chair. Good morning, witnesses. Nkombo is my name. Garen Nkombo, representing Mazabuka Central constituency.
Good morning, everyone. George Kasavira Kandafula, Member of Parliament, Serenje. Thank you.
Good morning, Technical Committee. I am Sibongile Mwamba. I represent the people of Kasama Central constituency and I'm a member of the Select Committee. You're most welcome. Thank you.
Thank you very much, Chairperson, and good morning, members of the Technical Committee on Consulting and Drafting Amendments to the Constitution of Zambia. My name is Brian Kambita, Member of Parliament for Zambezi East constituency in Northwestern Province and a member of this Select Committee.
Thank you very much, Chair. Good morning once again. Technical Committee, good morning. I'm Mishek Mtetwa Nyambose. I represent the wonderful people of Jasefu constituency in Eastern Province and a member of this committee. Thank you.
Technical Committee members, you are most welcome. My name is Muvita Anakoka. I'm a member of Parliament for Luena constituency in Western Province.
Thank you, Chair. Good morning, witnesses. My name is Newton Samakai, Member of Parliament for Mwinilunga constituency in the Northwestern Province.
Secretariat.
Good morning. My name is Christabel Maloa from the Office of the Clerk.
Permanent witness. Thank you. Witness Technical Committee. I am Imanga Onyema Jr., Member of Parliament for Nalolo constituency in Western Province, and honored to chair this committee by my colleagues. Witness, as you make your submission, I would like to take this opportunity to confer you with immunity as provided for under Cap 12 of the laws of Zambia, the National Assembly Powers and Privileges Act, which gives you immunity against prosecution for the submissions you make before this committee. The same immunity members of Parliament enjoy for the submissions they make on the floor of the Assembly. Witness, you are guided not to mislead this committee, or the reverse of the law applies. You are free to begin making your submission. I thank you very much.
Thank you very much, Chair, Honorable, and thank you very much for welcoming us as a technical committee to these proceedings. I would like to start by acknowledging the importance of these proceedings in the constitutional life of this country. But I would also like to prefix the work of the technical committee and its appearance here with how we are going to make our submissions, so that the honorable members of Parliament here can follow in terms of what we are going to submit. We are aware that we have a limited time to appear before you, so we'll be as much as possible succinct, but we will also try as much as possible to be substantive. So without much further ado, we'll start with a background in terms of our presentation, and there we'll just present the basis of the technical committee. And the basis of the technical committee feeds into every other aspect that we'll submit on. Following the basis, we will make reference to the terms of reference that we were appointed on as a technical committee. And here, again, I'm giving a prefix to what we are going to submit on. We'll start with the background. Following that, we'll speak to the terms of reference that the technical committee was appointed on. Thereafter, we'll speak to a methodology with which we received submissions from the people of Zambia with respect to particular terms of reference on the constitutional amendment process. At this point, I would like to pause and state that with reference to the specific terms of reference that we were called upon to receive submissions, there are synergies with the bill on the floor. We did receive a letter from the select committee to make comments on what is the impact of the submissions that we received from the people of Zambia with respect to what is contained in the bill on the floor. And we would like to state from the beginning, in terms of methodology, in terms of deliberation, and in terms of conclusion, that our submission here is strictly based on what we received from the people of Zambia, and that we did not necessarily deliberate on specific substantive issues on the bill on the floor. That has to be made clear from the beginning. But what also has to be made clear is that there are specific synergies with respect to thematic issues, and we will speak to those in terms of our recommendations, in terms of our observations, in terms of the rationale. And we did give the committee the full report, which contains most of those aspects. Following the methodology, we will speak to a number of substantive issues without being as broad as we need to be, because our report is as one may say, very large. But as you would expect, when the people of Zambia speak, the report will be large. the voices will be large, and hence the nature of the largeness of the report. So without further ado,
witness, just for guidance, after the background and terms of reference, we beg that we skip the methodology, then we go straight to the submissions received. Or you may just briefly summarize the methodology, looking at the volume of the submissions, but you may proceed with the background terms of reference, but we beg that we go to the submissions as received and as based on your terms of reference. Thank you.
Thank you very much, Chair, and we are very very well guided. We will endeavor to skip the methodology, but to hasten to say that the methodology is also an important aspect of the work that we did. In essence, without the methodology, there would be no report, there would be no draft bill, and hence we will endeavor to just speak to it very briefly, but of course drawing the balance that we do not want to go so much into it. But in terms of the background, and I hope that you can allow me to proceed to make the submission of the committee as is already on the floor with the honorables. I hope that is the case. May I get a confirmation
Please,
of that?
please, witness, we have your submission. You are
Thank you so much, Chair. So, as Chair, you are already aware, and this is in the public light, the technical committee was appointed on the 2nd of October 2025 by His Excellency the President, and the appointment was made pursuant to Article 92 of the Constitution. I will not go into the deep intricacies of Article 92.1, Article 92.1F, Article 92.1G, but it was Article 92 of the Constitution to undertake a constitutional review, to receive submissions from the people of Zambia with respect to specific terms of reference that speak to specific terms of amendment. And as a committee, we did undertake to do so. In conducting the work, the committee was called upon to ensure that its process, its methodology is inclusive. I would like to buttress this point. I know that in speaking to this preamble, it may seem unimportant, but for us as a committee, as we deliberated, in the context of our independence, we want to buttress that point, that as a committee, we were called upon to listen to the people of Zambia, and in listening to the people of Zambia, we are called upon to listen to the various voices in the different demographics. And the demographics speaks to individuals, men, women, youth, children. It speaks to groups, it speaks to political
witness, you may proceed.
Thank you so much. I'm just paying an eye to what is happening in the room so that we don't lose ourselves. The mandate speaks to the different political affiliations, different groups, marginalized groups, women, youth, persons with disabilities. That was our mandate. And we want to prefix our position and recommendation that we did listen to these various voices. In terms of the terms of reference, which you already have, I don't know if I can go straight into reading them, but I'll be very quick. I think it is very important that as a committee, we were called upon to receive submissions from the people of Zambia with respect to specific terms of reference. Term of reference number 1 spoke to receiving submissions from the people of Zambia with respect to provisions relating to the electoral process and the electoral system as a whole. This aspect is very important. To a large extent, it has been missed. But specifically, provisions relating to, and would like to reiterate the fact that the specific term of reference, number 1, stated that we were receiving submissions from the people of Zambia with respect to the electoral process and the electoral system as a whole, number 1. And number 2, with specific provisions. So there was a generality to the terms of reference, and then there was a specificity with respect to the terms of reference. The specific aspects of the terms of reference are as follows: the delineation and delimitation of constituencies and wards with a view to 1, ensure fair, equitable and balanced representation and distribution of resources across the Republic. Number 2, the promotion and enhancement of effective participation of women, youths and persons with disabilities in elective positions, number 1, and number 2, governance institutions in accordance with the principles of inclusivity, equality and equity. I'll hasten to say that the principles of inclusivity, equality and equity are already stated in the Constitution according to Article 8, Article 9 and Article 7. Number 3, by-elections, considering various factors such as the cost of by-elections, the number of nominated members of Parliament, the filing in of fresh nominations after the resignation of a candidate in a presidential 1, parliamentary 2 and 3 local government election, transitional and statutory mechanism with a view to ensure predictability and clarity in the term of office of all elective provisions. These were the terms of reference that were specific to the electoral process and the electoral system, but bearing in mind the rider that it was a quest for the technical committee to look at the electoral system and the electoral process as a whole, but with these specific terms of reference. Number 2, term of reference: to receive submissions from the people of Zambia with respect to provisions of the Constitution relating to the term of Member of Parliament, 1, and office of Minister, number 2. Number 3, term of reference: receive submissions from the people of Zambia with respect to provisions of the Constitution relating to the hearing of 1, presidential elections, 2, parliamentary elections, 3, local government election petitions. And this was with a view to enhance the administration of justice in these elections. We need not belabor into what informed the specific term of reference. Number 4, to receive submissions from the people of Zambia with respect to the composition of local government, 1, and 2, the tenure of office of local government officials. Next term of reference, members and chair: receive submissions from the people of Zambia with respect to the definition of 1, a youth, 2, a child, 3, an adult. The next term of reference: receive submissions from the people of Zambia with respect to constitutional office holders, specifically with regard to the tenure of 1, the office of the Attorney General, 2, the office of the Solicitor General, and 3, the qualification of the Secretary to the Cabinet. The last term of reference we were called upon was to receive submissions from the people of Zambia with respect to provisions of the current Constitution 2026 Act number 2 on matters that are incidental or connected to the above terms of reference. Chair, you mentioned that we do not need to go so much into the methodology, but in very brief words, because the methodology informs our recommendations, which is primarily our business here. The methodology of the committee, I want to hasten to say that, number one, the committee, as stated in the statement of appointment, the committee was independent. Members of the committee can actually hasten to say that. The first core of business that the committee did was to adopt its own rules of procedure. In adopting its own rules of procedure, the committee then decided to adopt the method of how it will collect and collect the data from the people of Zambia. The methodology that we used is a number of fold. Number one, the committee received submissions physically from the people of Zambia in the different provinces. In so doing, the committee also received submissions from the people virtually from all the districts. In that, we are very thankful to Smart Zambia, who enabled the committee to receive submissions from the people of Zambia from all the districts. We were very thankful for that. We also placed submission boxes in every district, in every council, in every municipality, and we received written submissions in that regard. The committee also received submissions through the online platform, which was www.wethepeople.org. This was the first time that the committee or any constitutional amendment and review process was able to receive submissions from people from within and outside the country. So we did receive submissions from the diaspora to be inclusive. In essence, the committee was very inclusive in terms of the submissions that we received. Statistically, we received over 11,000. The exact number was stated, but I would just like to say we received over 11,000 submissions. The number is very important because in previous constitutional review and amendment processes, that number has not been reached except for one. There may be a number of debates as to what the statistics are, but I think that in essence we still speak to we the people. So we did receive these submissions, and these submissions informed the committee's recommendations, which I would like to get into if you may permit me. But if there are any questions at this point, we can stand down and answer those questions before we get into the substantive part of the recommendations and submissions of the technical committee, which really speaks to the crux of why we're here right now.
Witness, you're guided. There are no questions. Questions will be asked at the end of your submission.
Thank you very much, Chair. So, as we received the submissions from the people, as many as there were, and as gladly as we received them, and as diverse as the technical committee was, from how we did introduce ourselves, it was very deliberate so that the people can see that the committee was very diverse, that the committee was composed of independent members who retained their mind, and the retention of the mind was permeating through the deliberations that we made. We want to emphasize the point that as a committee we were independent, hence the publication of the report, hence the publication of our draft bill. So we did make recommendations with respect to what we received from the people of Zambia. The first recommendation we made was with regard to the electoral process and in the electoral system, and under that we made a recommendation on delineation and delimitation of constituencies, which stated that we thought or recommend the harmonization and the correction of omissions and mistakes in all constitutional provisions to ensure non-contradictions, non-ambiguity, and the harmonization of provisions of all electoral system and processes including the implementation of provisions that speak to the electoral process and the electoral system. As I stated, that part of our term of reference was to look at the electoral system as a whole and the electoral process as a whole. But we did make specific recommendations, and I would like to just go through them very quickly, if you may permit me, Chairperson, to amend Article 52 by inserting a new clause, which is at Clause 5, after Clause 4, which will allow a person who loses a nomination petition before a tribunal to appeal before the Constitutional Court within 7 days of the decision, and for the court to hear and determine the appeal within 21 days from the date of lodging the appeal. This speaks to the issue of nomination. Another important, but rather actually very important aspect, almost overwhelming from the people, the delineation of constituencies and wards should be conducted, and the number of constituencies and wards to be determined using a transparent process. We may speak to this aspect if you will permit us at a later stage, but this was the principal position that the people stated, that they want delimitation and delineation of constituencies and wards. People also submitted that they want an amendment to Article 68 to reflect the new number of seats in the National Assembly, and that the new numbers to remain locked in the Constitution. We will speak to this specific aspect because it touches on a number of other recommendations that we as a committee make. So we'll move on to the next recommendation, which is to amend Article 47 and Article 68, which is, and very importantly, to introduce a mixed member representation in the National Assembly based on proposed numbers for women, youth, and persons with disabilities, and also to engage with the Electoral Commission to appreciate the total number of new seats to be created that would replace the existing 156 constituencies provided in the current constituencies. This speaks to the aspect of proportional representation, which we believe is an issue that is touched in the bill that is currently on the floor and that the people of Zambia commented on. That is our recommendation, the details of which are in our report. The next term of reference and recommendation is to repeal and replace Article 58(5), which in this instance we were quite specific as a committee, and you will note that this is one of the instances where we are very specific in terms of the nomenclature, in terms of the semantics, and we propose the specific reading, which goes as follows, if you may permit me. The Electoral Commission shall, at intervals of not more than 10 years, review and, where necessary, the names and alter the names and delineate the boundaries of constituencies and wards, and provide under Clause 8 the new number of constituencies in terms of delineation and delimitation. If you may permit me to read recommendation number G, which is provide Clause number 8 under Clause 52 of the Constitution, which is to ensure that the details of the delimitation and the delineation should be prescribed in an Act of Parliament. The details of this recommendation and the rationale are already stated in our report. Suffice to state that this comes from the people of Zambia. Next recommendation, to amend Article 47 and 68 to introduce a mixed member proportional representation system and increase the number of constituencies. We shall not belabor into this because it already touches into the term of reference number 3 that we already highlighted.
Recording in progress.
May I proceed?
Please proceed, witness.
Thank you so much, Chair. We shall not get into the mixed member proportional representation because it already touches into another term of reference that I believe we already highlighted, which is also detailed in the report that we're submitting. We go to the next term of reference to amend Article 47 and Article 68 to introduce a mixed member representation system in the National Assembly, introducing women, youth and persons with disabilities. Now this is where we're getting into the detail of the issue, and in getting into the detail, the proposal is as follows. Number 1, 226 members of parliament holding constituency based seats. I repeat, for noting, as I see the hands of the honorable members here, 226 members of parliament holding constituency-based seats. 40 members of parliament holding reserved seats as follows. 1, 16 women. 2, 12 youth. 3, 12 persons with disabilities. And lastly, not more than 10 nominated members of parliament. Of course, the vice president, the speaker, the first and second deputy speakers, as the course of parliament may be, which always goes without saying. I believe we do not need to belabor this point. The next term of reference, the number of constituencies shall be locked into the constitution. In essence, Article 68 shall state the number of constituencies, and married to Article 58 on the number of constituencies of members of parliament. This may sound vague, but it is very particular. We were very wary that there are two systems that are at play. Number 1 is the mixed member proportional representation, which has 1, the constituency based seats, number 2, proportional representation. If that takes the 4, then Article 68 of the Constitution and Article 58 of the Constitution then guides in terms of how that happens. But if the status quo is retained, nonetheless Article 68(2), Article 58(1) then takes the 4. As a committee, we were alive to the fact that the people proposed a mixed member proportional representation. Hence our submission and our recommendation. We moved on the basis that this was the submission of the people, and therefore our proposals, even with respect to the number of nominations of members of parliament, the number of nominations of the proportional representation system, we did move on that, not assumption, but on that recommendation and submissions from the people. And as the case may be, that is what we are tied to in terms of our presentation. As such, we would propose a retention of Article 58 with regard to the number of wards. We will speak to this in terms of the fact that the people felt that the wards are sufficient, but the constituencies needed delimitation and delineation, the details of which are stated in the report. The last term of reference speaks to the harmonization of the electoral rolls and the electoral system. Again, we are cognizant of the fact that there are a number of provisions in the Electoral Process Act, in the Constitution, and in a number of pieces of legislation that need to be harmonized, which we do not need to preach to you as members of parliament. I think you already know what those provisions are, and we do not need to preach to you. But our message is the people have submitted and are requesting that those provisions which are not in harmony be harmonized at your behest. In essence, they're asking you to legislatively represent them more effectively with respect to the law and how the law interacts with their lived experiences. There are a number of issues that we as a committee faced with respect to the submissions of the people. More than anything else, as a committee, we want to state one very important point, that the constitutional amendment process, the constitutional review process, from what we heard from the people, is very important, and the different clauses of the bill that is before this committee, as well as the different aspects of the terms of reference, speak to their lived experiences. That is to say that the people of Zambia experience the constitution at an everyday level, and therefore that the clauses, the thematic areas of the constitution, the issues that are raised in the constitutions are not theoretical. Neither are there legal provisions. They are issues of lived experiences of the people of Zambia. And we as a committee witnessed that when we were receiving submissions from the people from across the districts. The people do feel the specific impact of every clause in the constitution, meaning that the constitution is an alive document. And as such, as a committee, we only hasten to say that we implore this select committee to take into account the voices of the people as extrapolated in the report that we have annexed to our memorandum. With respect to specific aspects, we are open to questions that the members may ask, but nonetheless we ask your forgiveness that we are broad, we are not very specific, and that is because we carry the overall voice of the people as we speak here, and we do not carry any other voice as a committee. Thank you so much, Chair.
Witness, are you done? I was thinking you're going to go step by step on your until we are done with your report.
Chair, I was having one eye on the time and also having one eye on the fact that you acknowledged receipt of the report, unless you wanted us to go into the details. But as we spoke to the specific terms of reference, we also spoke to the specific aspects that we received submissions on, and we wanted to enrich this process by ensuring that we are more than anything else able to respond to specific concerns. We are aware that you have our memorandum, and rather than just reading it, we thought that we have made our point, the point which is that what as a committee we stand on is the voice that the people extrapolated, which we crystallized in our report, and we cannot go beyond the report of the technical committee, and that is what we want to submit on. But to enrich the process, I think we will be happy to respond to specific questions.
Witness, we have your memorandum, but as you are aware, the committee is interacting with various witnesses, so we would guide that we quickly go through until the very last page. We're on page 11. We go through until we reach page 19, where you feel you can give a succinct submissions. You can do that. You are the primary witness to this bill, so we don't want to be very brief. We just want to be as substantive as we can. So while we appreciate the document. The public out there would want to hear from you as a technical committee on the specifics that have not been mentioned. So witness, you are guided to continue.
Thank you very much, Chair, and we are happy that we can get into the detail. It is our desire, and we are happy for this opportunity. In terms of recommendations, we have the following. Number one, effective participation of women, youths, and persons with disabilities in the elective positions and governance institutions. The recommendation that we made as a committee is as follows: to amend Article 47 to Article 57 and Article 58 of the Constitution so as to provide a mixed member proportional representation electoral system as follows. I want to just make sure that we're following, Chair.
Yes, please proceed.
Thank you so much. Number one, the first past the post electoral system for members of parliament contesting under a constituency based seats based on the delimitation and delineation already proposed. As already stated, the people proposed the delimitation and delineation of constituencies. So in terms of the number of the first past the post, it will be based on the delimitation and delineation of constituencies. Number two, proportional representation on the electoral system for elections based on a party list where voters cast their vote for a political party appearing on the ballot and not for individual candidates listed in the party list as prescribed. That is the proposal for a party list. Another recommendation is to provide for a percentage of representation based on the number of proportional representation system on the proposed party list. The number of constituencies based on the constituency-based seats. To just explain this, as we stated, the exactness of this provision is really in the detail of what will be adopted. That is, number one, what the party list will consist of. Number two, what the constituency-based seats will be consist of based on the proposal for the delineation and delimitation of the constituencies. If there is need for elaboration of this specific aspect, we are happy to do so. But if you can permit us to go to the next recommendation, which is to amend Article 68 2B to include the number of women, youth, and persons with disabilities, which may also require new clauses as to how the nomination of these marginalized groups will be nominated. Again, we believe that this is a very self-speaking recommendation for the committee, unless you require us to make further elaborations. Another recommendation is to insert a clause to the effect that the seats under the proportional representation electoral system shall be distributed after an election by the Electoral Commission to all political parties in proportion to the total number of seats won by a political party in the election, calculated as a percentage of the vote a party received and prescribed. This is a specific aspect with respect to how do we actualize the proportional representation. With reading the body language, I can tell that there are questions on this specific aspect. But if you want us to elaborate, we can. But without further ado, the details are in the report. But nonetheless, we will hasten to say that, yeah, we do understand that sometimes when you read the specific clause, it is a mouthful. It is a very compounded sentence, but a recommendation from the people nonetheless, whose details are contained in the report, which is public and also before you as honorable members. So we need not belabor the point. the point is already made in our report. We go to the next aspect of the terms of reference and recommendation. In addition, a new clause should be inserted to the effect that winning candidates who contest the election under proportional representation electoral system shall be chosen from the top of the closed party list in the order of preference set by the political party. This is another intricate detail into the issue of proportional representation. There will be a party list. The party list will have a specific order of preference, and this particular recommendation speaks to how the actualization of number 1, number 2, number 3 on the party list features in the electoral system. Again, we are open to questions if there are any. The second term of reference, bearing in mind that what we just highlighted were sub-terms of reference on a specific issue of nomination, speaks to the issue of by-elections, an important aspect in our democratic life and in our constitutional life. The recommendation is as follows: maintain the current constitutional provision of by-elections. That was our recommendation. We justified the reason for the maintenance of by-elections. Again, the report is there with respect to why the committee recommended the retention of by-election about the need for democracy, constitutionalism. The details are in the report. We go to another important term of reference and important recommendation, which is the number of nominated members of parliament. The committee recommends as follows: to retain Article 69 on nomination of members of parliament, and under that to amend Article 68 2b to replace the number of nominated members of 8 members of parliament with 5% of constituency-based seats at any given time. If the clause is ambiguous, we are open to explaining why, but we have no doubt that the members of parliament understand the percentage of 5. We also have no doubt that as members of parliament you appreciate why we used the words constituency-based seats under this specific recommendation. We are, as consistently saying, ready to support and buttress the point as to why, without getting much into it. Another important aspect of the recommendation, a strong one if we do say so, which is the filing in of fresh nominations after the resignation of a candidate in presidential 1, parliamentary 2, and local government elections. This was one of those issues that was very intimate, not only to the people but also intimate to the honorable members here. The recommendations are as follows: to amend Article 52(6) so as to ensure that elections should proceed after the resignation of a member following nominations. Again, we think that this is a very self-speaking, self-executing recommendation unless there are very specific questions. Number 2, that there must be a clear timeline under Article 52b of the Constitution in the event that fresh nominations are required to be filed. And in this regard, we propose to amend Article 52 to provide for 1, that the sponsoring political party to file fresh nominations in the event of death. We hasten to say that the clause was dealing with resignation, but in the event of death, the sponsoring political party files a fresh nomination. that other candidates not to be made to pay for the filing in of fresh nominations in the event of death. And again, very self-speaking. In the event of disqualification by the court, the elections should proceed. And a political party shall be given 7 calendar days. We are quite specific in our nomenclature in using the terminology 7 calendar days within which to file fresh nominations in the event of death of a candidate. This particular term of reference, we went into detail based on the submissions from the people as to how we deal with resignations in the event of nominations. Another term of reference speaks to transitions in terms of statutory mechanisms, and the recommendations of the committee are as follows. Amend Article 81 of the Constitution to state the term for member of to state that the term of member of Parliament is 5 years, and that even if Parliament is dissolved 3 months before elections, members of Parliament shall be paid for the full 5-year term, having been deemed to have served 5 years. Unless honorable members want us to deliberate on this, but I think it is very self-speaking. We may even solicit a smile for this one. That there shall be a harmonization on the tenure of elected positions and maintain 2 5-year term limit for the president. Already very self-speaking. The term of member of Parliament and the office of minister. The committee recommended as follows based on the recommendations from your people. Maintain the status quo that there should be no term limits for members of Parliament. Self-speaking. Contained in the report in terms of the rationale and the objective. 2. Amend Article 116 and Article 117 to provide for the appointment of ministers and provincial ministers from outside Parliament, subject to ratification. A strong recommendation coming from the people, permeating through the different provisions that speak to the electoral process and the electoral system as a whole. And I would like to state the rider here that the first term of reference did speak to the committee making submissions, receiving submissions on the electoral system and the electoral process as a whole. This particular recommendation permeated through all those, but nonetheless a recommendation that the people made. The hearing of presidential, parliamentary and local government election petitions. This one is also non-contentious. Amend Article 101 sub-article 5 and Article 103 sub-article 2 to replace 14 days with 21 calendar days, which includes Saturday and Sunday, despite the provision under Article 269D for presidential election petitions. The detail of this is based on the following other proposals, which is to amend Article 73 sub-article 3 to include 30 calendar days for determination of appeal from High Court for parliamentary election petitions, to amend and to add the word determination after the word here in all presidential, parliamentary and local government election petition. This is a very important general provision that wherever there is the terminology to hear, there should be to determine, bearing in mind the history of election petitions and what is contained in the current constitution. Again, a very self-speaking, self-executing provision. Next term of recommendation, to provide for a specific time frame for petitions to be heard and be determined, which is 30 calendar days. That was the aggregated proposal or recommendations. And that for local government election petitions, the status quo should be maintained, which is that we retain the provisions in the current constitution, which within the scope of this discussion we may not get into. Another important aspect and recommendation is the composition of local government and the tenure of office of local government officials. Recommendations are as follows: to maintain the status quo that members of parliament should not form part of councils. A recommendation based on the submission from the people. That Article 153, Sub-Article 2, Sub-Article C remain as is contained in the Constitution, unless we want to read the specific article, but we may not have the time unless called upon to do so for purposes of clarity. That Article 153 should adopt the proportional representation system for election based on a party list system for women, youth and persons with disabilities as a party of mixed member proportional representation. This really speaks to the local government election. In essence, the recommendation was that the reflection on general elections should be reflected at local government elections. Other recommendation: amend Article 152B to abolish the 2 5-year term limit for the mayor or council chairperson. That is to speak to the fact that the term limit should be abolished for mayor and council chairperson. That is again a specific recommendation. Another recommendation speaks to the definition of youth, child and adult. The following are the recommendation of the committee based on what we received, which is to amend Article 266, the definition clause of the Constitution. Youth to mean a person who has attained the age of 18 years but is below the age of 35 years. Child to mean a person who is below the age of 18 and inclusive of an unborn child. Adult to mean a person who has attained and is above the age of 18. Again, these are very self-speaking provision, also non-controversial. We go to another important but also very administrative issue that the technical committee was asked to deal with in terms of reference: the tenure of office of Attorney General and Solicitor General and the qualification of the Secretary to the Cabinet. Recommendations are as follows: to amend Article 178, Sub-Article 1, Sub-Article 8, and Article 179, Sub-Article 4, Sub-Article A of the Constitution to ensure that the sitting Attorney General and Solicitor General remain in office until the next Attorney General and Solicitor General assume office. And to amend Article 176, Sub-Article 3, to provide that a person qualifies to be appointed as Secretary to the Cabinet if that person, 1, has or had at least 5 years experience at director level in the civil service. I would like to repeat this: has or had at least 5 years experience at director level in the civil service, and has or had at least 5 years experience as a permanent secretary or equivalent rank. that is the amendment of Article 176, Sub-Article 3, with respect to the qualifications of the Secretary to the Cabinet. The last term of reference where we made recommendations on is with respect to matters that were connected or incidental to the specific terms of reference. We did make
Proceed, witness.
Thank you so much, Chair. We did make recommendations with respect to matters that were incidental and connected to the terms of reference. If you may permit me, Chair, I want to state that this particular term of reference was also very important in the sense that the recommendations that we make permeated through the different submissions on the specific terms of reference. So the recommendations are not without a point, neither are they without a grounding. They are based on specific terms of reference, but they permeated through the different specific terms of reference that we received as a technical committee. Number one recommendation, the appointment that ministers should be appointed from outside Parliament. That councillors should be paid gratuity. Further, submitters propose that councillors and ward development committee members should be paid a salary. This is the second one. Again, we shall not belabor the point unless called upon. To replace the words grade 12 certificate with words school certificate. Those were the very intricate aspects of the other aspects. Of course, there were many others, but they did not to a large extent touch on the aspects of the terms of reference. But as members may notice that each of the recommendations touches on the specific experiences of the people with respect to the constitutional provisions and the amendment. And as a committee, we did our best to capture the voices of the people, and we were as inclusive as possible. So to conclude, would want to submit before this committee that whereas we did not specifically deliberate into the specific aspects of the bill that is on the floor, we are cognizant of the fact that thematic areas in the bill on the floor touch on the specific aspects that the people of Zambia submitted on in the work that we did, and our submission is that those recommendations, those submissions, and the voices of the people of Zambia as crystallized in our report should be taken into account with respect to the bill that is on the floor. We carry that voice of the people, and we cannot go beyond the voice of the people. Thank you so much, Chair. We submit.
Witness, thank you very much for your submission before this honorable committee. Honorable members, that's the submission from the Technical Committee on Consulting and Drafting Amendments on the Constitution of Zambia, appointed on 2nd October 2025 by the President to consult the people. Those are their submissions. You are now free to interact with them in that regard. Honorable Nkombo, Honorable Sefulo, and Honorable Samaka, in that order. Witness, you may take note of the questions, and you'll be guided to respond. Honorable Nkombo.
Thank you very much, and thank you very much, Acting Chairperson, for the committee. I want to begin by submitting before you, Chair, that probably, maybe not even probably, this is the largest voice that we are witnessing today from all the lined up witnesses, and therefore we want to thank you most sincerely, because your voice today has been condensed from more than 11,800 submissions, and therefore we want to thank you for that. I have a question regarding the proportional representation electoral system and how the numbers play out on the allocation of seats post an election. In the event that the presidential candidate fails to garner 50% plus 1 vote, we would have gone through an election and then would prepare for another election. At that point, before going to another election, my assumption would be that the proportional representative seats would have been apportioned to those who are deserving. So in the case of another run, which ballot will we rely on to allocate those particular seats? The second ballot, or which will be a two-man generically, including women, two horse race? And others would have fallen off, but in the first ballot they would have gotten some seats. I hope I'm very clear on that.
Honorable Safulo.
Thank you so very much. My question is on the recommendation that has been done on the MMPR system, where we are saying we are proposing 16 women, we are proposing 12 youths, and 12 people living, 12 people with disabilities. I wanted to get your take. These are coming through party lists, but then we have CSOs that represent, for example, people living with disabilities in Zambia. That will be better. That will be placed in a better position to choose their representatives to come through to Parliament, but who are not also politically affiliated. We also have youth organizations that will be in a better position to pick for the youth that are better representing them, opposed to everyone else coming through political parties. So I wanted to get your take, and this I'm also getting. I was privileged to see what is happening in Morocco. Not everyone that comes through the PR system has to come through party lists. They use other CSOs where they are able to get this. For example, people with disabilities. Why should they come through party lists? I wanted to get your take on that.
Honorable Samakai.
Thank you very much, Chair. Witness, I draw your attention to page 18. Page 18, where you're talking about the years of experience for Secretary to the Cabinet. You have put 5 years for 5 years experience for someone who is operating at director level, which is effectively Deputy Permanent Secretary. And also in 2, you have put the same number of years of experience for someone who has operated at a higher level of a permanent secretary. Don't you think that there's supposed to be a difference, because one has operated at a higher level and the other one has operated at a lower level, and you are requiring them to have the same experience in that position?
Thank you, witness. I hope you are taking note. Honorable Anakoka.
Thank you, Chair. Technical Committee, I see you are very, very specific on how the seats, the PR seats that is, should be shared, and my focus is on your submission that this should be done on a closed party list system. Given that you were also looking at regional practices, did you pick in some of the countries, the risk that goes with a pre-published list where people know that if X disappears from the face of the earth, I will be the next one. In fact, in one of our neighboring countries, when I mean N.A.B, I'm just talking about regional, the government had to set up specifically a special task force to deal with political killings, specifically for that purpose. Why? Because politicians were being eliminated at a very, very high rate. And in that country, they use a pure PR system and party list. So would you be sympathetic to the idea that maybe this list should be one that comes after an election has been held, once and for all, only if a vacancy occurs? If a vacancy does arise, again the parties that are affected will use their own internal mechanisms to come up with the replacements. Thank you.
We'll take the last one from Honorable Mngandu, then we'll ask the witness to attend to those.
Thank you, Doc, for your presentation. My understanding of your submission on the PR system, you've used, I think, the words "as prescribed" about 3 times. Is that the details will not be contained in this document? Instead, those details are likely to be put in a subsidiary legislation. Is that so? So that the fears that the honorable members are raising probably will be addressed in that subsidiary legislation after taking all the factors into consideration. Is that so? Kindly confirm. I submit.
Witness, you are guided to respond to those.
Thank you very much, Chairperson. I would like to background the answer to the specific questions that have been asked by the honorable members with this, that each of the recommendation and each of the submissions that we have made with respect to proportional representation, with respect to the qualifications of the secretary to the cabinet and every other aspect, is based on the submissions that we received from the people. That is a grounding point. So going specifically to the issue of proportional representation, would like to preface the answer with respect to the fact that, number one, apart from receiving submissions from the people, we did do a literature review. What the literature review revealed is that from 1991, 1996, 2006, in the constitutional amendment and constitutional review processes, the people of Zambia have asked for a proportional representation system. The proportional representation system that is proposed in the report that we have submitted before you is no different from what has been the cry of the people since 1991. It remains the same. In essence, we capture a long-standing voice, and I would not like to belabor that point, but hasten to say that it has been a voice that has been stated for a very, very long time. Almost to say that there is an opportunity now to actualize it as recommended. So proportional representation is as is. The actualization, Honorable, in terms of whether it should be a party list, in terms of whether it should be a quota system, more than anything else, people have always called for a party list from 1991, from to 1996. Even in the Mungomba and in the Silungwe, it was a closed party list. The reports are there. The literature review reviews that, and we received submissions on that. As a committee, we want to make the point that as much as possible we did not want to intellectualize and over-intellectualize the submissions of the people, because that is not what you do in a democracy. You just carry the voices. And what we recommended is what the people have said. But we are also buttressed in our point by the fact that that voice that we received this time round was also the voice that we read in other constitutional review processes, in other constitutional amendment processes. So we are happy that we are echoing a voice that has been long-standing, which has been a party list, which also answers the question of the other honorables, that there has to be a closed party list. But what are the dangers of a closed party list? I do not want to mention certain words that in our deliberations were used. We heard 1,000 voices of the people of Zambia, and in doing so we had a good laugh. We were happy. We had yeah, but the members are trying to say, did anyone mention witchcraft? But I don't want to say that I heard it, but I think that's what I'm hearing here, but it's not my word nonetheless. But anyway, for a light moment, but nonetheless there were a number of fears that were allayed. But that also speaks to the nature of democracy. But there's nothing that is without risk. Every process, every democratic process will be with its risk, substantive or non-substantive. And this issue of nomination is as such. And those issues, those risks were appreciated. But nonetheless, the recommendation was made as such. So yes, the risks were taken into account, but the recommendation was made nonetheless, taking into account those risks, which is that, it was about the principle rather than what we fear. In essence, it is the proverbial, people moved with what they wanted rather than what they feared. With respect to the office of Secretary to the Cabinet, there is a two-tier proposal that is there, unless it is not clear, Honorable Somaka, but that is number one, it is 5 years experience at director level, and so the 5 years is a minimum. Then the other 5 years should be at least as permanent secretary. So in essence, it is a reduction of what is currently permeating. What is currently permeating is 10 years as permanent secretary. But the people submitted that they do recognize that it may be difficult to find a person with that level of experience, and so maybe the reduction should be on the permanent secretary level, which is 5 years, and then 5 years as director, which is a reduction in terms of the experience. To a large extent, we believe it is self-speaking, but we're also happy to make it more clear in terms of the drafting language. But we are not drafters nonetheless, but we hope that we communicate the point that it has been reduced. I don't know if I've answered all the questions. Honorable Khumba, did I address?
The two questions have not been answered. The question on prescribed, that Honorable Ngandu raised, Honorable Kombo gave a scenario of 50 plus 1 when at presidential level none accrues 50 plus 1, and there's that PRR system. So which do you take? Is it the rerun or the initial? Or what was the spirit of the people if that came about in the submission?
Okay, so if cognizance is taken to our report, which is really a crystallization of what the people say, the aspect of proportional representation speaks to two things, and there is a specific language that is used in the provisions of the recommendation. One, proportional representation, mixed member list, party list. Party list therefore presupposes one thing, that it is parliamentary. Number two, constituency-based lists, which also presupposes the parliamentary seats. That was the presupposition of the people, according to what we gathered, according to what we proposed. As you will see from our recommendations, the proportional representation did not touch on the presidential vote. Unless you would like the committee to get into proportional representation in the context of a presidential vote, which we did deliberate on, but nonetheless the people did not indulge us to do so because of their submissions. So their submissions were strictly speaking on parliamentary list, and hence proportional representation is based on parliamentary seats. Parliamentary seats being in the dichotomy of 1, constituency-based seats, 2, proportional representation seats. So the question of a rerun and so on does not even come to the fore, because that is not what we got from the people. I think that answers the question. The issue of prescribed is also an important one, in the sense that, one, as a committee, the people did prescribe that the number of seats should be locked into the constitution, meaning that there has to be a mechanism within the constitution as to how the number of seats in parliament have to be stated. So prescribed does not exclude the constitution, but nonetheless there were a number of feelings that, okay, so how do we actualize some of these provisions? But as you see from the spirit of the submissions, the overall is that the number of seats and the number of members of parliament should be, the word used, locked in the constitution.
Thank you, witness, for those responses. Everything's answered. We'll get the next round. Honorable Kambita, Honorable, you can proceed.
Thank you, Chair. Mine is a follow-up question. The first one is on the amendment of 176 in relation to Secretary to the Cabinet. Our witness, we all understand the reason why this has been proposed is because in the country we don't have people who have like 10 years experience as permanent secretary. However, the proposal was included, but in your submission you are saying that someone should have 5 years experience as director level and then 5 years experience as a permanent secretary. Now I think sometimes we need to approach issues as the environment where we are. I know that we have few people in this country who served as 5 years director and then 5 years permanent secretaries. Why I ask this question is because if you look around, most of our PSs, some they are coming from outside the civil service, but they are serving as permanent secretaries, meaning that after 5 years they'll have 5 years experience as permanent secretary, but they never served as directors at the ministerial level. So now I want to understand how we'll handle this scenario, considering that we have someone 5 years experience, so 10 years experience as director, and then there's another one who has served 5 years as permanent secretary, but they never served as the director. They came outside the civil service. That's my submission, Chair. Then the second one is on the PR system to do with the youth. The age of a youth in this country is below the age of 35 years. Now, come next year, he comes under the party list with the age of 33 or 32 years. Within the life of Parliament, they go above 35 years. What happens? Should they remain in Parliament or they should be replaced? What is the line of thinking from the technical committee?
Honorable Kakuho, then Honorable Kambita.
Chair, thank you very much. Vice Chair, I would like to draw attention to the issue of by-elections on page 12. Committee takes note that on this submission, you've done a bullet submission, just one line, and I quote, maintain the current constitutional provisions on by-elections. Now, I would like to find out whether you'd care to just give a bit more information as to what reasons citizens felt, what were their compelling feelings towards this matter. Chair, I ask because this Parliament on an annual basis allocates millions of kwacha to run by-elections, and also in addition to that, Vice Chair, if you check the figures on by-elections, usually they are characterized by serious voter apathy. So sometimes citizens, I think they prefer to show up on a general election. When there's a by-election, they concentrate on other things in their lives. I thought if you could add a bit more information to this line that you've given, the committee would be assisted in making its report. Thank you.
Thank you. Honorable Kambita, then witness, you can.
Thank you very much, Chairperson. I'd like to get your attention to page 11, Vice Chairperson for the Technical Committee. Effective participation of women, youth and persons with disabilities in effective positions and elective positions and governance institutions. In your submission, of course, there's one submission you made that look, most of the things we have put here are the people's aspirations, what people actually submitted as what they would wish to go into the constitution, and that ties most of us in terms of what questions we want to ask based on that insulation you've given yourself. But again, I just want to clarify from you, since you had the direct engagement with the people, if you go to page 12 on D, where you are suggesting that we need to insert a new clause to the effect that the seats under the proportional representation electoral system shall be distributed after an election by the electoral commission to political parties in proportion to the total number of seats won by the political party in an election. I just want to find out from you in categorical terms, because one is on basis to be used, which is the method really to come up with these people who are in the marginalized grouping, and the other one is to find out from you if there were any submissions that were made suggesting to base it on the presidential results, because here you are submitting from one point of school of thought, which is basing it on the results of the constituency electoral college. So were there any other submissions based on the presidential vote, going by the fact that the constituency based depends on the ballot, a ballot being administered at constituency level. Now, if the basis is the after the elections, what would you recommend as the basis, the appropriate basis? I hope I haven't been too ambiguous.
Thank you, honorable members. Witness, you are free to respond to those, and where you feel other members of the committee can indulge, that is very welcome. Honorable Daka, is it on the same? Okay, no, you witness can proceed.
Thank you very much, Chair. I take note of the questions, and I believe that I speak on behalf of the committee. That number one, on every aspect of the recommendation, and I won't be shy to make this point, that on every aspect of the recommendations, on every aspect of the submissions we have made, it is on the basis of what the people submitted. About to say that there was not an over-intellectualization of every aspect as they came from the people on the basis of democracy, but nonetheless we did deliberate. With respect to the question that has been asked on the nominated members and how that is to be done, I believe that was the question, Honorable. I think the essence and the recommendation is basically what is contained in the report. There were a number of considerations that were being made. That also brings me to the fact of the issue of the secretary to the cabinet and its dichotomy. The feeling, as stated in the report, as you will note, number one, the overall observation was that the office is very important and that it cannot be undermined, but also that there has to be a level of compromise in terms of who qualifies and who doesn't qualify to be there. And so the aggregation of the submission was on the fact that perhaps to be pragmatic, there has to be a reduction of the qualifications, and that is what we got from from the people with respect to that particular office. I would like to get to, before I get to the others, because the question that you ask, Honorable, is very important to respond to the answers that have been asked, which is regard to our feeling. But as a committee, number one, most of the aspects that we got were informed by the people, and in many respects what we did get is the fact that in different constituencies, in different districts, we had a mixture of those feelings, but we did get an aggregation, and what we have recommended is that aggregation. What I want to avoid, based on the words that you use, is what is the feeling of the committee. It is, our submission is not really just the feeling of the committee. It is really about the overall submission that we got. That point I want to buttress. There are specific issues that you members have asked. I would like to call upon Ms. Jala to respond to part of the specific aspects that the members have asked. By elections.
Maybe if Honorable Chair, if the member can just repeat the question on by-elections. I'm just, yeah.
By-elections, Honorable Kako.
Well, I'm happy to repeat the question. I was referring to the issue of by-elections, and I did mention that I noticed that in your submission there's only one line that states that we maintain the status quo. So without taking anything away from the submission and also respecting the wishes of the people, I wanted to find out if you'd care to mention some of the reasons the people gave in your interactions with them as to why they would want to maintain by-elections, and also if you can speak to the fact that you feel people are aware of the cost implications of by-elections. So your comment on that is what I was soliciting here.
Thank you very, very much for that most important question, Mr. Chair. The major issue here was Zambia is a multi-party democracy as pronounced in the constitution. That's the major bottom line. And we do, as a nation, practice democratic governance. So they felt very strongly that by-elections should be maintained as a democratic element of our elections. They felt that political parties should maintain the right to choose their candidates and put those across to the electorate to get their vote on a political party ticket. But while acknowledging the fact that the Constitution does allow for independent candidates, but those are in the minority. The majority actually follow the democratic dispensation of this country. So that's why they felt strongly that you could not choose, a political party cannot just choose a person to replace an elected official. It's still their right to elect their representatives. I'll end there, Mr. Chair.
Just to buttress that point, I asked Ms. Jala to make that point. One, because of the experience she's had on different aspects of the constitutional life of this country, so she was better placed. And I think that the point has been made. But overall, as you will note from the report, there was a bullet point on by-elections. But I started the preamble of our submission by stating that the committee was asked to make recommendations on the electoral process and the electoral system as a whole. Permeating through the different submissions were two, if you may permit me to use the word, a tale of two cities, where on the one hand it was appreciated that by-elections are costly, and on the other hand it was appreciated that by-elections are necessary in a democracy. Of course, through the permeation and submission, there was a high level of dissatisfaction about the number of by-elections that we have as a country and how costly they are. And so you could see that the majority of citizens are dissatisfied with the number of by-elections. They are unhappy about them, and they don't want by-elections because of the costly nature of by-elections. But you could also see permeating through their submission that they wanted to retain their democratic right to choose a leader, and hence the recommendation that we made as a technical committee. And I think that if you allow the proverbial tale of two cities, then you understand why we made that recommendation. And thank you.
Thank you, witness. Honorable Sabal and Honorable Daka. You had did you have an intervention?
Chair, mine is not a question, but I had an observation on the vice chairperson in his responses, he puts a disclaimer in most of his responses, but my understanding is that they own this report as a committee. They went out there and then they came up with a report. But there's also some responses where you can also bring your own wisdom, but most of the responses there was too much of a disclaimer. So that was the challenge I have, Chair.
On that person, if you may permit me to respond.
Yes, proceed.
Yes, it is very important to respond to that particular one. As we stated, as a committee, we are appointed to receive submissions on specific terms of references. We did receive the terms of references from the people. The disclaimer is not to insulate us. The disclaimer is to ensure that we retain the dignity of the submissions that we receive from the people of Zambia. The disclaimer is to ensure that it is not our voice that permeates through this hearing. We are a conveyor belt. As much as we would want to get into our own mind, but we are not here to speak our mind. We are here to conveyor belt and communicate what is in our report. Hence, if Honorable Chairperson, you permit me, in our letter responding to what we got, we submitted the full report of the committee. We submitted the annexure of the draft, which is really the voice of the people, and that is what we want to stand on. As you will notice, we are not overanalyzing any of the provisions for a deliberate reason, that the analysis is in the report, and the report is public, and you can quote us from there, but we don't want to get into so much of ourselves, because we're not here for ourselves. We're really just here as a conveyor belt. That was our planned response, and we'll stand on that as a committee.
That is well guided. The views of the people take expression through your report, but we want both yourselves and the people to own the report, because the people didn't draft. It was you as a committee. So but however, we take note of what you're saying. Honorable Mngandu, then Honorable Daka. Is it on the same? To a cabinet. Okay. Honorable Daka has been pending for some time. Then you come in.
Thank you, Chairperson. It's on page 14 on the filing in of fresh nominations after resignation of a candidate in presidential, parliamentary and local government election. Witness, under C on page 14, number 1, you have submitted that the sponsoring political party to file fresh nomination in an event of death. But I would like to find out what happens in an event of an independent candidate dying. What did the people say? I submit, Chairperson.
Thank you, Honorable Daka. Honorable Mngandu, then Honorable Nkombo.
Chairperson, Deputy or Vice Chair, I want you to just confirm. Secretary to Cabinet, you indicated that someone must first be a director, then 5 years director, then 5 years PS level. Is that to protect this position, to avoid, probably, that's just my interpretation, to avoid people coming from nowhere? Sorry to say this, but someone just indicated here that it's possible for someone to be a permanent secretary. In short, on a party political lineage system, someone becomes a permanent secretary, and yet they have no idea of what civil service is. Then tomorrow they become secretary to cabinet. So is that the reason why you've indicated that someone should first be a director for 5 years, then become a permanent secretary, or the two are exclusive of each other? If yes, why? What is it that we are trying to cure? Because my understanding of 5 years was simply to reduce or give a wider choice, because it's difficult to find people who have been in civil service at permanent secretary level for 10 years and they are still what I would call active age. You'd find there are people that have already retired. They've reached retirement age mostly. What is it that we want to cure? Then the final one is on page 9 of your report. Recommendation of 260 and 26 members of parliament holding constituency-based seats, 40 members of parliament holding reserved seats as the. But my point is on 226 members of parliament holding constituency-based seats. What was the rationale behind this? How did you arrive at this number? In short, this is the proposing chair an increase by 15. Was there any background? It's saying 226 members of parliament holding constituency-based seats, meaning we should have 226 constituencies. This is what this report is saying. So I want to find out, is there any empirical evidence behind this that we might not be aware of as this select committee? Is it a delimitation report that you've seen somewhere, or what is this based on? What is this based on, so that we know what we are? Because to be honest, your presentation and your report has a higher weight because you are getting these submissions from the people. What is this based on? I submit, Chair.
Thank you, Honorable Mungando Kombo. You can proceed. Then witness.
Thank you very much, Chair. I'm also stemming from page 9 in the same article, but allow me to use my own wording to get clarity out of what Honorable Member for Chama South has said regarding these numbers. The committee assembled these numbers into this report, and because numbers are absolute, I would not want to believe that these numbers were communicated to the committee for conveyance. They must have been assembled somehow, because I see some were in Eastern Province, others were in Western Province. How possible is it that the whole country could come and assemble these numbers? And also making reference to the technical committee report of 2019, it did have recommendations, Chair, on how many constituencies required to be added to the existing ones. The bill also has its own proposal of 45, I think, extra constituencies. 55, yes, thanks for correction. And your report, together with the people of Zambia, your report is suggesting about 70. Are you stemming from the 2019 technical report, or stemming from the what you may know that we may not know, the available resources to actualize this from the executive, or it is just abracadabra that these numbers have come from the whole country? 226, 40, 16 women, 12 youths. I suppose you sat as a team to consolidate these and put them in this report. And whilst I know, Chair, that we have been stuck on delimitation for a long time because of the provision in the constitution that dictated that there shall be 156 constituencies. Now that we are curing this, and if the 2019 report is something to go by, why didn't you follow that, the 2019 report, so that the issue of delimitation is packed away for a very long time to come? Malawi, reasonably small country in terms of land size, has so many constituencies compared to Zambia, so much so that even if you followed the 2019 technical report, we would still be behind Malawi in terms of absolute numbers of constituencies. Please help me to understand.
Witness, this is still around the same issue, so I'll allow Honorable Sabao to ask.
Thank you, Chair. Mine is on page 8 in relation to the delimitation. Delimitation should be conducted and a new number determined using a transparent process. Chairperson, can you guide us what you collected from the majority Zambians on what is it that they want that is transparent? What is this transparent process? I submit, Chair.
Thank you, Honorable Sabao. Witness, those are your points of clarification from the members. You may proceed to respond.
Thank you very much, Chairperson. I will start with the question on delimitation. And I think that as a committee we can be brave enough to say that the issue of delimitation was one of the most submitted on aspects. I don't think that any of the members of the committee can fault me by saying that if there was one issue that the people strongly submitted on was the need for delimitation, I can almost dare say here that if the people had their way, each constituency would be divided into 2 or 3 from the submissions we received, because there was no district, no constituency, no submissions where someone didn't say we want our constituency to be divided into 2 or 3. That was a submission. I can almost say that I don't think any of the committee members would fault me in saying that the people said that they want this delimitation immediately. I'm being bold in doing so, but I think it is a reflection of what people were saying. It was almost as if they were tired of listening and speaking about delimitation. So that is a specific need, and I'll start with that. Yeah. May I continue, Chair?
Please, witness, proceed.
I was saying that I would dare say that it was one of those aspects where we felt that the people gave us a sense of agency, gave us a sense of need. It is highlighted in the report. The contestations about it are neither here nor there for us. For us, we heard what people said, and we make mention of that. In terms of the issues that were raised about delimitation, there were a number of words that were consistently coming out in both English and the different languages that were coming. One word that came out, vastness of the constituency. Another word that came out is effective representation in the constituency. Another word that came out, or the nomenclature that came out, is representation of the constituency. Another word that came out is the ability of the member of parliament to buttress the constituency. Some constituencies were too big. Another word that came out is equity of CDF, an important aspect. Another word that came out from the people is the issue of the changing demographics. Another issue that came out is climate change. So there is a whole list, but this list is already presented in our report, and that is why we call on the select committee to look at what the committee has said with respect to delimitation and delineation. So in terms of the transparency of the process, the people, as they spoke, they gave us indicators of what they want to permeate through that process and so on and so forth. The devil will be in the detail of what goes forward. So that is the issue of delimitation and delineation. With respect, I'll get to the question of the number of 226 members of parliament. It does relate to a certain extent to the issue of delineation and delimitation. Of course, as a committee, we are not demographers, we are not mathematicians, neither are we topographers. But when we listen to the voice of the people and we get the crux, if you look at the number and you divide it, it gives us 7 provinces. 7 more provinces. 7 seats. 7 seats. Yes. 7 seats in each province. And that is now the division. Part of our report explains that. Part of the reason we gave the map in the report is to just see, if you look at the colors of each of the districts, you will see how unequitable the districts are, and also how unevenly the constituencies after the divisions are. We can only call you to look at that particular map. It was a deliberate inclusion in the report, but it is 7 seats in every province. The devil again is in the detail, but the detail is informed by what I already highlighted, honorable member, and that is with respect to the different aspects of the number of seats. So that is the issue with respect to the delineation and the delimitation. Yes, there was a question with regard to the independent candidate on resignation. To a very, very large extent, I'll be very honest that a lot of members did not address themselves to that particular issue. But if you get cognizance of the report, it does say that where there is a resignation of a member, other political parties and also other candidates should be allowed to file nominations. There is also another rider that those that have already paid should not be obliged to pay. And that was an important aspect, because it kept on coming out from the people that you disrupt elections when there is a resignation, but a party or a candidate has made a payment. So if you look at the rider on the issue of payment, it addresses the fact that the payments that have been made at the initial nominations should not be discounted. They should be taken into account. And the only aspect that is where the person has resigned and then there is a fresh nomination that has to be made, and there is also a specific time frame. So people submitted even beyond the issue of the fresh nomination, but also in terms of a time frame as to when a fresh nomination should be done in the event of death. In the event of resignation, it is self-speaking that the election, it goes on. But in the event of death and others, those thresholds were given in the recommendation. I also want to make the point that in terms of the terms of reference, it was resignation, but death and all those other aspects were not part of the terms of reference, but nonetheless people did make comments, and hence the appearance of those particular recommendations in our report. Yeah.
Witness, thank you. I just want clarification on these two issues. Okay, let me see, then you can come to Honorable Solomon. On the issue of PR, the 16 women, 12 youths, and 12 with disabilities, is it equally informed by the distribution around the country? Maybe you can clarify that one. Then on the definition of a child, to mean a person who is below the age of 18, inclusive of an unborn child. Inclusive of an unborn child. Need a bit of clarity on that. If a child should include what is unborn. Yeah, Honorable Sefolo, you can proceed.
Thank you so very much, Chair. Listening into the Vice Chairperson saying, I wanted to get more clarity. You can't just say we are going to give seven constituencies to each province, because each province is different, and it's also geographically different. We have provinces that are very, very bigger than other provinces, and provinces that are smaller in size than other provinces. Also, the population and other things that other factors that are involved. So, Chair, I'm not too sure, because what should inform the recommendation of the number of seats that should be in Parliament should be the report that is done by ECZ, because like you said, you're not demographers, you have not the expertise that ECZ has in order for them to be able to recommend for delimitation. You said you do not have it. So I'm not understanding how you can just say across board we recommended for 7 constituencies to be added when they are geographically also different. So do you think that is the way that we should proceed, for delimitation to be informed by just cutting across, or they should have been informed by ECZ who have the technical expertise for them to to handle delimitation and delimitation? I submit.
Thank you very much. Witness, before you respond, I would like to guide if there's any of your members on the team who can take over from you, as you are required somewhere urgently, and unless if you want to quickly attend to those and leave, so you, particularly for the Vice Chairperson.
I will go ahead to respond to the questions very urgently. I note the need to step out. It's almost always been a tradition, but I want to answer the question of the Honourable Member about the ECZ report. One important issue is this, that the recommendation of the technical committee highlights its independence. We did take cognizance of the fact that there were other committees that went round, but our report and our recommendation is based on what we received, and we did not want to go beyond what we received, and that is an important point that we want to buttress. So it is really based on what we received. We also did take into account the fact that submitters made a recommendation on the basis of what permeates in their constituencies. But I think I've consistently used one terminology, which is the fact that the devil is in the detail, and the detail is in the report. And again, in trying to as much as possible answer the question, but also in trying as much as possible to ignite interest into our report, I will say that I invite the honorable members to actually get into the detail of the report, as well as the members of the public to get into the detail of the report. It does really speak into it, but most of the issues are answered. With respect to the question on the unborn child, I wish one of my colleagues who was one of very instrumental in it was here. But if you look at the current penal code and the current laws, they use the word unborn child, and that is a definition that is consistently there, and as such it will, and as such it is, we felt that there has to be consistency in that, and I'm happy that next to me is Father Milwa, who was also one of those that felt the need to make mention of it, and I'll take advantage of him being sitting next to me. Sorry, I'm ambushing you, Father, but I know that you were there, and
yeah. So I think our constitution has documented that we are a Christian nation, which sometimes you see when you go in detail, you want to forget about what you have proclaimed yourselves to be. So if we are a Christian nation, we can not only go up to, I don't know where there is such a figure as 0 in terms of life, but we are talking about where life begins. And if we say a child, it qualifies.
Chair, may I excuse myself for a matter that you know?
Yes, you're well guided.
I'll be
Witness,
back
please,
in the shortest
please proceed.
moments.
Please proceed.
Just briefly to add on to the voice on the unborn child, we are talking about the value of life here, and we're a Christian nation. As we put together rules that govern us, we may not go completely off and forget what our value system is. I believe that the Constitution is not only a document that governs us, but it's also an ethical document that promotes life. So I think it was born from that argument that we have this opportunity where we are deliberating. We may not just say from under anybody who is under 18, or why don't we go beyond the silent voice of a child that we don't see. I think that's where it comes from.
Okay, please, you can proceed with this.
Thank you, Chair. Part of that actually comes from the Constitution itself, Article 12, which deals with the protection of life, and this is just to buttress that we are a Christian nation. In number 2, it says a person shall not deprive an unborn child of life by termination. That is where in the Constitution you see the unborn child, and that is why we wanted it to be all the same.
Yes, witness, we take note, and the reason we're asking is that we already have a Child Code Act which has entrenched this definition from the current constitution. So, and with all this lack of consistency, the committee must really familiarize itself with the implication of expanding definitions and what abuse, and this particular Child Code Act, which entrenches its definition from what the Constitution provides today of what is a child, also entrenches its definition from international recognized treaties. So it's a matter of should we amend maybe what is existing, or should we remain? So it's an interesting, and we're happy that as a committee you've brought it out as a technical committee, so that it will be a subject of scrutiny. I don't know, honorable members, if we are still engaging the witness on points of clarification. It seems most of the issues that that required clarification, the honorable members have asked. So with this being the case, witness, we would like to thank you as a committee collectively most sincerely for the work that you undertook, having been appointed as a technical committee on 2nd October. And we do recognize the valuable work that has been done in consulting the people, and your submission is a primary submission of our work as a committee, considering that it represents the biggest constituency of witnesses. So we would like to wish you well as you leave this committee, and to take away the immunity that we bestowed bestowed on you. What you say, you're on your own from here. Yeah, you're on your own. But we would like to take away that immunity and allow you to enjoy the greater immunity that you enjoy as citizens of this country, and only to wish you the best in your endeavors, and to recognize that even your submissions that are outside the objects of our bill are well accepted and well adopted by this committee, and that there will be no need to do any future work with regards to consultations on other issues outside the bill, because you've extensively asked the people. So we thank you most sincerely, witness, and we wish you well.
Chair, thank you very much for those kind words, and on behalf of the technical committee and on behalf of our chair who couldn't be here, we do appreciate this opportunity.
You are watching Parliament TV, the only station dedicated to bringing Parliament closer to you. Taking over controls from Matimba Mkua, I am Joe Akatama Muyunda, and of course sign language interpreter Chola Kawama. So that was the select committee which was constituted to scrutinize the Constitution Amendment Bill, National Assembly Bill number 7 over 2025, which has been receiving submissions from various stakeholders starting on Friday and also over the weekend. So today the committee did just receive submissions from the Electoral Commission of Zambia, ECZ, and a few seconds ago the committee received submissions from a technical committee appointed to consult people on constitution amendment. So we still do expect the same committee to receive submissions from the new Congress party. We urge you to stay glued right here on Parliament TV. Right now we'll go for a break. We'll be back on the other side.
My eParliament mobile application. First, download the app on either Play Store or App Store